Hi everyone, I'm Amy Friesen. So today we're going to speak about Bill 7, what families should know, and just a couple of housekeeping items. There is, so please remain muted. There's also a chat box at the bottom of your Zoom where you can put in the questions. We'll answer questions at the end. So just put them in there for now and we'll go through them. That's about it for housekeeping. So let me introduce you to everyone. So again, my name is Amy Friesen. I'm the owner of Tea and Toast here in Ottawa, and we specialize in helping folks transition to senior living and give elder care advice. And today we also have Jeanette Bach with us. She's also a colleague of mine. She specializes in the Toronto and West area. Toronto West. And our speaker today is Christine Morano from Advocai, and she is a lawyer in Toronto. I'm going to let her take it from here. And again, if you have any questions come up, please put them in the chat and we'll chat with you soon.
Hi, everyone. Thank you for joining us today. So yes, as Amy said, I am a lawyer in Toronto. I specialize in elder law. So that means that I do a variety of work that deals with elderly issues, including I do personal injury work and long-term care and retirement homes. I deal with personal injuries that happen in the community. I also deal with substitute decision-making disputes that arise in the course of hospital discharge matters. They can also happen in the community as an older adult's capacity starts to change, or there's some warning signs. Sometimes things like guardianship, elder abuse come up and arise, and so those are the sorts of issues that I specialize in. I have my own firm. I worked at the Advocacy Center for the Elderly, where I was an institutional advocate. So I would work primarily with older adults dealing with hospital discharge issues. And so I continue to do patient advocacy work. However, the landscape for that work has changed quite a bit since I started doing it in light of Bill 7. And that's what I'm going to be talking to you about today. I will say that all of the information that I provide today is information, right? So it is not intended to be legal advice, and it's always best that you consult with a lawyer if you are facing these types of issues. Or you may be in a position to advocate for yourselves or for your clients, and that's also great as well. So what is the More Beds, Better Care Act? So this was passed on August 31st, 2022, and it became law without any real public consultation. The purpose was to free up hospital beds. Now, the patients that this legislation targets weren't actually taking up a, huge number of these beds. So it's interesting that that's, what its intended purpose was. And it didn't create more beds. So in any event, what it did do was it created a mandatory first bed available requirement for patients in hospital. I'm going to elaborate on this later in my presentation, but essentially it's you're a patient who no longer requires acute care in hospital. There's this bed available in long-term care, you got to take it. It targets elderly patients in hospital who no longer require acute care and are waiting for a different level of care. Now, it doesn't just target those waiting for long-term care. It also targets those patients that the physician or other hospital staff have determined no longer require the resources in the hospital. This Bill 7 actually has an impact on them as well, and I'm going to get to that later in the presentation. So I think it's important, before I get into what Bill 7 has changed and what looks different, that I talk about sort of what the process was before. And so if you were a patient in hospital who was eligible for long-term care and you were waiting for a home of your choosing, the hospital was only entitled to charge the chronic care copayment. And that was a payment that would be made to help pay for the cost of meals and accommodation. And a lot of people weren't really familiar with what this fee was. You know, patients would often be surprised, their families would be surprised that the hospital could even charge in these circumstances, but they could. They didn't have to charge the chronic care copayment, but they could if you were waiting for long-term care. And the maximum amount, as I've outlined in the slide here, is currently $63.73 per day. It might have been a few dollars lower, you know, each year, or it's $19.38 a month. Now that was a maximum. So this chronic care copayment was essentially calculated based on income, and there were reductions available for patients who were low income or patients with dependents. And so prior to COVID-19, one of the other differences was that ALC patients, so those waiting for an alternative level of care, so waiting for long-term care, could only be placed in the crisis category for admission in very limited circumstances. So these would be things like the hospital is being shut down, or the hospital is experiencing severe capacity issues. And in those cases, a patient could be put on the crisis list to go to the long-term care home that they've chosen. But it was pretty rare. So that's, you know, sort of in terms of waiting in hospital, that's what it looked like prior to Bill 7. And the process for actually getting into long-term care, the application process looked quite different from what it is today. So at least legally, it looked different. And I say that because there was sort of a disconnect between what was required in law and what would actually happen in practice. But essentially, consent of the patient was considered fundamental. So a patient is in hospital. If they don't have, so they would be able to commence. So they would reach out to what's home and community care support services to get the application started. This is also known as the LIN, or was known as the LIN, sorry. So they would reach out, an assessment would be done with the patient's consent. And if the patient was incapable, their substitute decision maker, which typically would be a family member, would make these decisions. So they would request the application be done. They would consent to the actual assessment. They would consent to the release of the patient's personal health information to the long-term care home so that they could assess whether or not they could meet the person's care needs. And the patient or their substitute decision maker would select the long-term care homes that you know, they wanted to put on their list. And when a home you know, accepted the patient, it would be up to the patient to consent to the admission. And in the past, the placement coordinator, so this is typically someone who's working for home community care support services, they were only allowed to assist in the application process, right? So if the patient says, oh, I need some help, you know, what do you think are some homes that I should be looking at or whatever, the placement coordinator could assist in those circumstances. But they sort of, in terms of making choices, their role was very, very limited. And, you know, part of this process, really, that the patient's considering things like location, religion, culture, the type of accommodation they can afford, because I'm sure, as many of you know, the different long-term care homes cater to different preferences, needs. So these are the sorts of things that people would be looking at, and that would be important. In particular, being close to family, that's obviously something that's important to a lot of people. And, you know, as I said, in terms of consent, it was on the patient or their substitute decision maker every step of the way. At least that's what the law provided for pre-Bill 7. Now, that was the law. On this slide here, I'm going to talk to you about what really happened in practice. So in practice, I would get lots of calls when I was at the Advocacy Center for the Elderly, and even at my current firm, from patients who were being bullied or harassed, or their family members were being bullied or harassed by hospital staff, sometimes, well, various members of the hospital team, being told you have to accept the first available bed. That's what we're seeing under Bill 7 now, right? But that was sort of what was being told to patients even before Bill 7. You got to accept the first available bed. You don't require acute care. You got to go. Patients were being advised that they could only be assessed for long-term care if they left the hospital. So you need to be in the community if you want to be assessed for long-term care. Patients were led to believe that they would have to go to a transitional unit, which is an unregulated type of setting where there are, you know, it's not like the same, you know, sort of laws and regulations that apply to long-term care don't apply in those settings. They're not retirement homes. Nobody really knows what they are, but you got to go there. You got to go there. You got to be admitted there, and only then can you get into long-term care. And in many cases, people would be panicked because they would be told you have to pay the uninsured daily rate if you wait in hospital for long-term care. The uninsured daily rate is sort of basically what we hear about now, right? With this $400 a day that can be charged. I'm going to get to that later in my slides. But at the time, this uninsured daily rate, there was no maximum set out in the legislation. So it could be $200 a day. It could be $700 a day. And so patients or their families would be told, if you choose to wait in hospital for long-term care, we're going to charge you this uninsured daily rate. So although the law provided for some protections and consent was fundamental, there were a lot of problems in practice pre-Bill 7. And a lot of times patients would have to hire someone like myself or maybe a patient advocate just to ensure that their rights were respected and that they were being given the right sorts of opportunities to actually like go through the process and choose and so on. So that's an ongoing issue, and Bill 7 unfortunately has given the sort of sad reality legal standing, and I'm going to get to that in the next few slides. Okay, so that's where we're coming from, and following Bill 7, I'm going to talk about what's happened. So it applies to alternative level of care patients, and I've referred to this already. So it's a patient who's in hospital, and it's a patient who's been designated by the attending physician as requiring an alternative level of care. So that could be a patient who is going to, who's suitable for long-term care. They're no longer acute. The physician may say long-term care seems appropriate for this person. It could be that they're no longer acute and maybe home care, some sort of plan of care offered through home community care support services is suitable. It could be, maybe a suggested retirement living. I've seen all sorts of different plans suggested by hospital, whether or not the family can or the patient themselves can actually afford them. But it's essentially, this legislation is targeting those patients who aren't acute and are in a hospital bed. And it's typically elderly patients, because, as I'm sure many of you know, when an elderly patient ends up in hospital, it's usually because it's usually not it can be a life-changing event, which means that, they can't return to their home. There's a lot of moving parts. Family has to figure out what's going to be done. Maybe they can't return home anymore. It really changes things. So that's who this legislation is targeting, and unfairly, in my opinion, because it targets the elderly. And it's changed the process from a legal standpoint. So, as I said earlier, there were problems, but we always had the law to fall back on and kind of deal with these issues. And a lot of times I was able to get them resolved, right? So if the hospital was bullying a patient and, not allowing them to go through the correct process, that would be rectified. Now, what the law has done is allowed for placement coordinators to commence an application for long-term care on behalf of the patient without their consent, determine their eligibility without consent, collect their personal health information, release it to the long-term care homes, and they can select one or more long-term care homes on the patient's behalf, and they can authorize their admission. Now, the legislation says that reasonable efforts have to be made to obtain consent. It's not really clear what that means. However, I have seen the field guide that is used by the placement coordinators, and it looks like this basically means at each stage, at each bullet point I've listed on this slide, you try to get the patient's consent. But to me, this is sort of like I don't think that this idea of reasonable efforts really makes any difference, because, if the long-term care is being proposed, the person refuses, then, they can just move on and do what they want to do, essentially. So that's the current process. And it continues to require, right? So I talked earlier about how pre-COVID, ALC patients, alternative level of care patients in hospital were crisis. They continue to be crisis category. So that means that a lot of the patients in hospital will have priority over those awaiting placement to long-term care in the community. And the only way in which, and this was the case under the old legislation, and I've laid out 2 reasons why the home can refuse. Those remain the same. So these could be the home lacks the physical facilities to meet the applicant's care requirements, or the staff lack the nursing expertise necessary to meet the applicant's needs. These reasons why the home can refuse are they're important. Oftentimes, like in most cases, homes will accept patients. Having said that, these I find are helpful more for patients. So, there's the hospital's trying to free up beds. The home and community, the placement coordinator is trying to, get them into certain homes. And so the home sometimes will accept, even though they shouldn't be accepting, right? So if somebody's got a lot of complex assistive devices, they've got complex needs, they may be told that this home can accept them, but actually the home should be refusing them. So, at times I've actually used these sections to say, look, the home doesn't have the authority to approve this application because they can't meet the person's care needs, for example. The home lacking the physical facilities, this one sort of, it applies more to like older homes that need to be renovated, where maybe the hallways are narrow or the rooms are too narrow for, wheelchair, say, or something like this. It's very rare to see someone refused on that basis, though. So these are important to keep in mind, not only because they can be used as reasons to, ensure that the person's going to the correct home, but also because if somebody's being refused for another reason, right? Like say, that the patient has dementia and we don't have the supports here to care for them. Well, that's just flat out wrong, in my opinion, because that's precisely why long-term care homes exist, right? So if that's the reason, if you're a family member and you're being told that your loved one can't go to a particular long-term care home, you may want to look long and hard at the reasons why, because nursing expertise is a reason that it can be refused. When it comes to dementia, we're not really talking about nursing expertise. What we're talking about is having staff that can take the right sort of approaches with these particular residents. So that remains the same under the legislation. And I just want to highlight it because sometimes people are confused about when a home can refuse to accept, or, how sometimes those actual reasons can be helpful to you as a family member. So now the placement coordinator can authorize admission even to preferred accommodation. So if you're a patient in hospital, you're not consenting to long-term care, or maybe you are consenting to long-term care, but you're not consenting to the particular homes that are being proposed by the placement coordinator. If you've said, look, I can only afford basic, they still have the authority to move you into like a semi-private or a private room at a long-term care home. But in those cases, the ministry would pay the top up essentially, because semi-private is going to be more expensive than basic. And you can see here on the slide that patient will be charged the basic rate in those circumstances because they didn't request that. And the patient will be placed on an internal transfer list. And so if basic accommodation is offered within the home at a later date, if they're ever able to get that kind of accommodation and it's refused by the patient, then they will be charged that preferred rate. So whatever the semi-private room actually costs. And one important thing to keep in mind here. So yes, the placement coordinator can go through this entire process without the consent of the patient, and you can get all the way to the point where, the home is agreed to admit the patient, but the hospital can't physically transfer the patient to the long-term care home without their consent. Nobody can place hands on the patient without consent. So, albeit like physically they can't do it, but, and I'll get to this, I think it's on the next slide, the patient's kind of forced to go because of the fees that a hospital can charge in these circumstances. But it's just important to keep that in mind. Nobody can actually place hands on the patient without consent. So following Bill 7, there's these geographic restrictions now, and I use the word restrictions rather loosely because it's sort of limitless, as you can see. So a placement coordinator can authorize admission within 70-kilometer radius of the patient's preferred location if they're in Southern Ontario, and within 150-kilometer radius from the patient's preferred location if they're in the Northeast LHIN or the Northwest LHIN. So in particular, when we're talking about the Northeast LHIN or the Northwest LHIN, if there are no home vacancies, the placement coordinator can choose the next closest home to the patient's preferred location. And you can see at the bottom of the slide here, sort of said preferred location is and how it's addressed. So it's either based on, if the ALC patient does have homes that they've agreed to go to and they just happen to be different from the ones that the placement coordinator is putting on the list, their preferred location be identified based on the homes, that the patient is selecting, or the address of their residence. If they don't have a home, then it's just based on where like the location of the hospital. So this is what I was talking about earlier. I said that a patient can't physically be moved without consent, but under the new legislation, so Bill 7's amended the Public Hospitals Act, and it requires that the hospital charge $400 per day after 24 hours when a discharge order is made, if the patient refuses to leave the hospital. So you're not forced to go, but you kind of are, because who can afford to pay $400 per day? And this fee doesn't just apply to those patients who have been offered a bed in long-term care. It also applies to those patients who, as I said earlier, aren't acute, and maybe a physician or another designated staff member feel is more appropriate for their care needs, right? So this could be sort of like home and community cares come up with a home care plan, and the staff at the hospital think that that's appropriate for you. And so, if they choose to discharge you and you remain in hospital, you are now facing this $400 a day charge. And previously, the hospital wasn't actually required to charge fees while someone was waiting for long-term care. More often than not, they did, but they weren't actually legally required. The law is really strong on this point now. And so here are the situations where they can charge, and I've sort of laid this out already, but a bed offer's been made, patient refuses, or patient's been discharged with a different plan of care, whatever that may look like, and they make the decision to remain in the hospital. So this $400 a day charge is pretty much forcing patients to, go to places they don't want to go, or to get treatment from places that they don't want to get treatment. And it's very scary. And obviously, it's part of the reason why a lot of patients, I'm throughout this presentation, I sort of talked about consent versus not consenting, and how you can pick your preferred homes, and, the LIN might have, or the home and community care placement coordinator may have other homes, right? And it's important that you maintain your position throughout the process. So if your position is you're not consenting, you have to continue to say that, because, and they can't charge you the $400 a day unless you refuse to leave when a bed offer is made. But if you, I'm going to get to this on the next slide, if you continue to say, I don't want to go to these homes that you're proposing, then you put yourself in a better position, right? People will often be like, oh, they told me I was going to be charged $400 per day, so I added certain homes to my list. You don't want to do that. You want to continue to say no, 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 and let them go through their process and keep the homes that you want, if there are even homes that somebody wants to go to. So, and here's part of the reason why. So if you look at the first bullet point here, if a patient is placed in a home chosen by the placement coordinator and not chosen by the patient, right, they will remain on the crisis list for up to 5 homes. So that means that if they've got other homes they picked, they get to maintain crisis status for those other homes, and they could be transferred at a later date. And I believe the patient has 60 days to add homes, and they'll still get to treat them as crisis. So after they're moved, there's 60 days. And I've said here, you're likely going to be required to consent to the transfer. Maybe you're not consenting to anything else in the process, but you agree to actually move. If you do that, if you just maintain your position, the point I made above about remaining on the crisis list stands. If you cave under the pressure, you add the homes to the list, then you really have no preferred homes. There's no longer preferred homes versus home and community care chosen homes. You've just got one list, and you're not going to be allowed to add any other homes to your crisis list, right? Because you technically got into one of your preferred homes. So this is why it's important to maintain separate lists and make sure that, you know, the placement coordinator is doing that, and you've made your position very clear the whole way through. And if a patient is offered a bed in one of their preferred homes and they refuse, then they'll be taken off all waiting lists. So let's say you get into a home chosen by placement coordinator. You maintain your own separate list on which your crisis for all homes. If you get an offer from one of those homes and you refuse to go, then you don't get to be crisis for any of the other homes you put on there. Okay, so these are some of the legal considerations. There's currently a charter challenge to Bill 7. This has been brought by the Ontario Health Coalition and the Advocacy Centre for the Elderly. You may or may not have seen this in the media. They are claiming that it violates the right to life, liberty, and security of the person, and the right to equality, because older adults are being unfairly targeted. What's important about this is that I understand that they are still interested in speaking. The Advocacy Center for the Elderly is still interested in speaking with family members and patients who have been faced with these discharge situations and who are being forced to go to homes that they did not consent to go to, or they're, you know, facing these threats and going through the process, because it will help to, not only can they assist in these cases sometimes, but also it will help to inform the charter challenge that they're currently bringing. So that is just something to keep in mind. There are protections set out in the Personal Health Information and Protection Act. And what that piece of legislation says is that consent is required for the use and disclosure of your personal health information. Nothing in Bill 7 amended that legislation. And under that, under the provisions of what I'm going to call PHIPA, you can put a lockbox on your health information. And that is still something that is open to patients to do. What a lockbox does is it prevents those within the circle of care from seeing certain portions of their health records. And so if you are not consenting to be assessed for long-term care, or you're not you're not consenting to that process, it may be an option to put a lockbox on your health records, because that will sort of obstruct the process in some ways. They won't be able to look at that person's health information. The long-term care home will be able to take a look at it to assess whether or not they can take the patient, right? Now, there could be problems that arise in doing that, right? One is the hospital may still try to discharge, and there are other problems that could come up with doing that, but it is an option available, and it's certainly a way to slow the process down, especially if, a family member is getting all sorts of information thrown at them, they're feeling overwhelmed, they don't know what to do. Throwing out this section of the law and asking for a lockbox could be a way to get the process slowed down and maybe even change the course of things. This is all very new legislation, so this is just something that I'm mentioning, but I have not, as of yet, actually seen this used. And the last point I want to make, which I think is important for all of you to remember when you're dealing with your clients, family members, for patients themselves. Health practitioners have to act in accordance with standards, practices, and policies set out by their regulatory bodies. So they all still owe a duty of care to the patient. That includes a duty to discharge safely, right? And they need to follow all the policies that their colleges set out, and patients can still make complaints to their colleges. And, depending on what's at issue, whether it's, obviously if they're acting in accordance with Bill 7, that's not something that you can really make a complaint about. But sometimes what I'll see is, a patient's being sent home without any plan of care. And depending on who's responsible for that, that could be the basis for a complaint. Even sort of stating that, you are considering bringing a complaint could sort of, again, slow down the process and get people to sort of take a step-by-step approach and work through things the right way. So these are all important points to keep in mind. And I think that wraps up everything that I wanted to share with you all today.
So we should be able to pop our videos back on, hopefully. There we are. So if anybody has any questions, thank you, Christine. Very, very thorough. Thank you so much. I know that Jeanette and I, and as well as there's a couple of other advisors in this group watching, we definitely have a lot of clients that have been dealing with this in different aspects. A couple of questions that are in right now. One is Ottawa in the Northeast Lynn? No, Ottawa is in the Champlain Lynn. And so the Northeast would be kind of North Bay, I believe, Thunder Bay, super north. So Ottawa is not, we are in the Champlain Lynn here. So I think it's, Christine, it's 75 kilometers, from hospital there, or from the address?
Yeah, 70 kilometers, yeah.
70, perfect. And then, so Christine, how much time are discharge planners required to provide the family before they're allowed to start charging the $400 a day?
So the $400 a day can only be charged if you've been presented with a bed offer and you're refusing to go, right? So it's not just that you have been assessed and then you don't agree, but rather there has to be an actual bed offer made, and then you can be charged. Now, if you've been discharged and you're not waiting for long-term care, that's not happening at all. You can just be charged right away, right? 24 hours after discharge, you can be charged.
Christine, I have a question.
Oh, sorry. And I should also mention, so like if you're waiting for a long-term care bed, you've been determined ALC, you're waiting to go to long-term care, the chronic care copayment could still apply, right? It's just you can't be charged that $400 per day.
Okay. I'm thinking a lot of people on this call will have seen the pressure put on by discharge planners to families to get their loved one out of the hospital. And sometimes those discharge planning meetings with the families will happen one day. And in my client's particular situation, they were told that they needed to have their parent out by the following day. And when the family said that was impossible to even begin or to know where to go, they were told that they would be charged the $400 a day starting the next day. However, this discharge planner came up with a respite that was 77 kilometers away and made the family believe that that was their only other option, and they felt pressure, so they took that, and they were told they would remain on a crisis list because she was on a crisis list for long-term care. But then a variety of things happened and she was removed from the crisis list and then stuck out in Cambridge from Brampton, where she was put into hospital. So that's why I'm asking that question about what is reasonable when the discharge, when they've just told the family that there's a discharge.
So if in that situation, I because really, if the family's okay with long-term care or the patient's okay with long-term care and they've agreed to go, and it's just a matter of waiting, I can't, every situation is different, but I would say in that situation, the hospital's not authorized to charge the $400 per day until the bed offer is made.
Okay, right, that's what I thought.
But, you have to consider that in light of the fact that there could be another discharge plan that they're proposing in the interim. And if they believe that that's reasonable, they technically have the authority to discharge. So, it's like, it is unclear, I guess, is what I would say. But typically speaking, if somebody is waiting to go to long-term care and that process is underway, the hospital's not in a position to charge the $400 per day because they've determined that the discharge plan is in fact long-term care. But yeah, it's hard. These situations have to be looked at like on a case-by-case basis because the legislation really gives a lot of power to the hospital. And but yeah, I would think that in that situation, there's some wiggle room there to fight the $400 per day, right? Because if you've been determined eligible for long-term care, that means your care needs can't be met in the community.
Right.
It requires supervision by a nurse, and a lot of facilities besides long-term care are not going to meet that. Even long-term care can't meet that in some cases, as we all know. So I think there's some arguments there. I guess what I'm saying is, unfortunately, it sounds like in those situations you have to almost, which is so unfair, but you have to like hire someone like yourself to ensure that the rights of the patient are respected. It's absolutely ridiculous.
It is ridiculous. Anyways. Yes, thank you.
Christine,
Sorry, that was a long-winded answer, but I hope somewhere in there I answered your question.
Yeah, you did.
we have a couple more questions. So one is they'd like a little bit more information on the lockbox approach as a last resort. Like, how do you enact that process?
You just ask for one. So you tell the hospital, you can tell the social worker, you could tell the nurse that you want a lockbox on your health records. And that means that the placement coordinator is not going to be able to get access to that information.
Interesting.
But I will tell you, like, it's great that I'm mentioning that. And I think it's like an interesting idea to try. I haven't tried it. And I'm proposing it because I know that there's been no amendments made to the Personal Health Information Protection Act. But in practice, it could be very, very difficult to get someone to listen to you to actually make this happen, right? So in a lot of these situations, you're going to have to be very forceful and maybe put in a complaint with patient relations if you're not getting anywhere with the staff, or if they don't know what you're talking about, or, and one of the consequences of doing that, like I said, is, the hospital staff may try to approach the situation in a different way and find another sort of way around getting the patient out, right? But it certainly slows things down, and it can help everybody sort of reset and figure out what the next steps will be, because like Jeanette said, a lot of these situations happen in a very rushed basis on like a Friday afternoon when nobody's available to do anything, because hospitals are strategic. They plan their discharges at certain times. And I think anyways,
yes,
that's just what I've seen. And it's very smart, right? You try to catch somebody on a weekend or on a Friday, and it's going to be very difficult to get a hold of the people that, the family or the patient may want to speak with to make an informed decision.
Another question, how does Bill 7 apply to ALC patients who have been discharged from hospital to a temporary transition care? So in Ottawa, we have Greystone, which is a retirement that's been turned into transition. So how does that apply with the ALC patients?
Well, if you are, the transitional care is confusing because transitional care, it used to be clear what that was. It was an unregulated place that people would go to wait for long-term care. Now, I'm not certain when that term is used, if it's referring to an area that is rented out by the hospital with the hospital's beds, or if it's something else. In this situation, what do we know what we're talking about exactly? Because that makes a difference.
I think it's in our situation here, I think it's rented out, like it's, the hospital has reserved, there's a couple of homes here that have reserved like a floor or a greystone as a building through them.
So in that case, right, the hospital can transfer the patient there without consent. It's considered part of the hospital system, right? Consent for, it's not considered like, you're not leaving the hospital really. So I think you're hard pressed to say, I'm refusing the move. And then it would be like, from a legal standpoint, it would be like waiting in hospital for long-term care still, right? So all the same. Now, that's not the case for, and I hate to even use this in the context of like transitional care, because to me, that's not really transitional care. Like transitional care is more a place that's outside of hospital where you've been told you have to go and wait. Whereas it sounds like what we're talking about here is like an extension of the hospital, even though the care likely looks slightly different, it's still technically part of the hospital. And so, you know, the same sort of waiting process, crisis placement, and all of that would apply.
So Lori's follow-up to that, she just put in, but can they force you to go on a particular long-term care home list that is not, sorry, a particular long-term care home that's not on your list when you're being discharged to a transitional home?
Yes, because for as I understand it, that's basically like an extension of the person's stay in hospital, right? So it's kind of like all the same rules would apply. It's just they're sort of forcing you to kind of continue waiting from that location.
Lori's gonna unmute because I think she's gonna question here.
There, well, specifically, my dad is at the Greystone right now, and the placement coordinator at the Greystone he's on a list for her to go through the application so we can put in our selections for homes, which is fine. But she also said that she's been told by the government that in addition to whatever ones we select, they may require us to include a home or two that we don't prefer. And I wasn't sure how Bill 7 applies because they're not at a hospital anymore, and I don't know what our rights would be if then they do shove him off to something that he's not. Not one of his preferred.
Right. Based on what we're talking about, it sounds like that is actually part of the hospital. That's what I'm gathering, because it's a space that is rented out by the hospital that has hospital beds. So there's on the one hand, it sounds like the same process that would apply, you know, as if he were actually where he was prior, it would be the same. So they can go through the admission process without consent, and that means they can add homes. Now, if it's not part of the hospital, and that is TBD, I don't really know, but if it's not, then the question is, well, then I would say no, they can't. I don't know on what basis they would be adding homes to the list. But I, you know, it sounds like this is an extension of the hospital. It's a waiting area where people go, and they can kind of force you to add homes because the same rules still apply.
If it wasn't part of the hospital, I think it is, like, I agree with you that.
Yeah.
But what I have heard, and what my colleagues have heard as well, is that because, you know, separate to Bill 7, when people are applying for the top 5 long-term care homes, Lynn has been asking them to add more homes because the waiting lists are so substantial. And so I've heard that as well. It might be a mixture. It's one or the other, but I'm
Yeah,
not
you
sure.
don't have to. You don't have to add more homes at that point. Like, it's basically as though you're applying from in community, and you don't even need to add 5 homes, right? You can just put 1.
Mhm.
But by the sounds of it, in this situation, the hospital's got a bit of a hold on it because it's their facility, which means you're sort of subject to the hospital's rules. But it's tricky because although we're talking about Greystone being rented by the hospital, I don't know what that actually means in practice. And here's where we get into some of the real messy stuff.
I
There's
don't know if it matters or not, but the services are provided by Bayshore. They've been contracted out to, Bayshore Health, personal support workers and nursing. They're not staff of the hospital. I don't know if that makes any difference or not.
That would be through those services, then would be through the Lynn.
Yeah.
In the same category as what they would do at home, right, for home care.
So I would, I would suggest that you, it may be a good idea to ask some of those questions, right? And to say, I don't really understand why you think this process applies here. This isn't the hospital. This is a transitional unit. And put that to them and see what sort of response you get. But I will say that these situations in particular are tricky because the status of these units is unclear in law. And then you run into issues where you can't figure out, like, what's the framework here? I don't know what we're working with.
Yeah.
And I'm sure there's probably an argument on both ends to say, oh, this is actually the hospital. Or this isn't the hospital, right? But it's worth a shot.
Just ask for clarity. Yeah, for sure.
Yeah.
One comment that came in too is apparently no consideration has been given to the ability of family to regularly visit persons in long-term care, right? Because if they're moving that far away, it'd be hard to say the opposite of that.
Yeah. Sorry, we mean that through the selection process for long-term care.
It's just, it's a comment about moving 70 kilometers, 150 kilometers, like they're not, essentially, they're not holistically looking at the clients, right? They're saying, okay, you don't fit here anymore. And this is, you're moving 70 kilometers away from your family. And then, and we've seen clients, they've slipped up or someone says, accept everything. And then we're saying, no, don't accept everything. And if they do, then they're, like you said, they're off the crisis list. So they can't even, what the chances of them moving back to the area is nil as far as
Yeah. And like one important point, which I don't think I made clear, is so the crisis list has different tiers, right? So just because you're crisis, it doesn't mean that you're going in as the next person on that list, right? Like, in that field guide that I was referring to earlier, I think I noted in there when I was reading it, it said, consideration has to be given to the urgency of patients in hospital, which means, I think, that generally speaking, patients in hospital waiting for long-term care are going to place higher on the crisis list than those who have been placed in a home that they didn't want to go to, unfortunately, which could mean that, maybe you never get into that home that you wanted. But going back to my point earlier, I think it's still important to maintain your position of no consent so that at least you leave yourself open to moving later. Otherwise, the alternative is you're just on a regular wait list for that home, which means for sure you're never going to get in.
Christine, one other question I had, I see there's a couple of other questions, but one I have is, my concern is when the hospital determines that somebody that has moderate to advanced dementia is going to be a candidate for this type of transfer, and talk about vulnerable and needing advocacy from their family. Is there a way to supersede that decision? Is there a way to stop that if your loved one is in that category of having a moderate to advanced dementia, not being able to advocate for themselves, and then being moved 70 kilometers away from their family members who would normally do that advocating for them?
It's possible to, a lot of things are possible. I can't speak to whether or not I think this is going to be successful. My days of advising people on this is a sure thing are gone when it comes to hospital discharge stuff, but you can certainly try to make the argument that that person's care needs are not going to be met in that home because their care needs are too high and you're their primary caregiver, i.e. if you're the person's spouse, and you're going to be required to be there to get them to take their medication or to get them to eat because they have a tendency to engage in certain types of behaviors. They're going to be resistant to care. If you can sort of make that point and really get the placement coordinator to understand, you may be in a position to kind of argue for that the distance is just, it essentially means that they don't have the expertise to address this person's care needs. But you're going to have to, as I said earlier, right? Like it sort of goes both ways. Long-term care homes should be set up to deal with residents who have dementia, right? And there's behavioral supports in place and they're supposed to be trained in all these strategies. But the reality is there are staffing shortages and there's a lack of just overall
Yes.
I'll leave it at that. There's a lot. Yeah. There's a lot lacking at times. So it's not inconceivable that someone with advanced, with a really deteriorating condition is going to require a lot of support from their family members. And maybe the starting point for that kind of argument is to say, this person's been in a hospital. I've been going every single day to make sure that they take their meds because otherwise otherwise they just won't take them, or I've been going every day because it's the only way that they'll eat. If you can kind of make your case out, but I think if it's just a situation where you're not all that involved in the care and you want to have the ability to visit frequently, I think it's going to be a harder argument to make.
There might be a little bit of the argument too, like some of the long-term care, most are locked buildings, but lots don't have locked floors, right? Which would signify, that they possibly don't have an extensive memory care activity programming and things like that. So kind of whatever you can use to make that argument, right? Like there might be some flex in that as well.
Yeah, you can certainly try that. And then of course the other side to that argument is like, well, they're not really allowed to, they don't have the authority to lock up patients, even though locked floors exist, which is a whole other story. But I think that those are helpful that's like a helpful, in reality, these locked floors exist and they're there to address patients who have significant behavioral issues. And so, yeah, to Amy's point, I mean, why not try to use that to make that point?
The other thing I wanted to bring up in the conversation that Jeanette and I had, just for information purposes, is that this bill is really only sticking to the public sector, right? Where there's many of us even on this call that we work in the private as well, in retirement living. And depending on what the needs are, it is feasible that a retirement home would fit the bill as well, fit the situation. And it's not being offered. And sometimes people are being moved 70 kilometers away to a retirement home. We've heard that as well. It's just been random. So in those cases, I would just make the statement that, it would be worth a while to look into the possibility or speak with somebody, like ourselves, just to have that conversation as to whether a retirement home would be able to fit the care instead of moving 70 kilometers away, looking at a retirement home closer to, obviously, taking into all the care, making sure everything's covered, but having that conversation, because a lot of people don't feel like they can do it, but there's lots of homes that can do quite a lot of care as well. So it's very client specific, but it is an option. Is there any other questions before we end today? And I don't see any other ones coming through. I'll give everybody a couple of seconds here. Anything else coming in? Okay, I think we're good. Oh, She's good. Christine, thank you so much for coming on. This has been very eye-opening. As I said, when we were putting together the slides, you know, I work in this environment and we know it, but just to get another, a legal standpoint from it is very, very helpful, because we have a lot of clients in a pickle, right? And so we're all trying to advise them the best as we can, but to have someone with your expertise is very helpful. So thank you so much for coming on and doing this. I really appreciate it.
Thank you for having me.
Thanks everybody for joining us, and we'll send out an email soon with a copy of the presentation for your records, and I hope everyone has a really nice day. Thanks very much.
Take care. Bye-bye.
Thank you.